Lord Hodge is unable to be here, as he is now in Scotland, but has agreed the decision and order which I am about to read. After consideration of the appellant's appeal against the order made by the Eastern Caribbean Court of Appeal, sitting as the Court of Appeal for St Christopher and Nevis on the 5th of February 2015, and having heard submissions on behalf of the parties yesterday on the 11th of February 2015, first, the Board will humbly advise Her Majesty that the appeal should be allowed, that the orders made by Madam Justice Carter on the 27th January 2015 and by the Court of Appeal on the 5th of February 2015 be set aside, and that the interim injunction granted by Madam Justice Carter on the 16th January 2015 be restored. Second, the parties having in their agreement and undertaking recorded in the order made by the Court of Appeal by consent on 5th February 2015 agreed to use for the purposes of the forthcoming election due to take place on Monday the 16th February 2015, whatever list the Privy Council may determine as the appropriate list, it is determined and ordered that, firstly, the list to be used in the said election is and shall be that existing prior to and apart from the proclamation bearing the reference number 2 of 2015, purportedly issued and published by the Governor-General in Extraordinary Gazette number 3 bearing the date 16th January 2015. Second, any effect which the said proclamation would continue otherwise to have, whether in relation to any other election or otherwise, is hereby suspended until further order. All further questions regarding the said proclamation or otherwise, and all questions of costs, be reserved. The Board will put its advice to Her Majesty and its reasons for this order in writing in a judgment which will be handed down in the usual way in due course. The Board is grateful to Council and those assisting them for the way in which this appeal has been prepared and argued.